This week we're going to be talking about criminal procedures, and I thought I'd start off sort of clarifying the difference between criminal and civil law, because without this clarification it's hard to understand what we're talking about. So it's important to know that criminal law and civil law are really two completely different things, and there's very little overlap. And it's important that as you think of different scenarios in the law, that you put them into one of these categories so that it can make some sense, so that you have a framework for looking at it. And I want to just point out two distinctions between criminal and civil law. In criminal law, you can be sent to jail. In civil law, you can't. You'll get fined some money, but you're not going to be ever sent to jail. You can't lose your freedom because of a civil case. Now, under criminal law, you could also be fined instead of going to jail or other things. So jail isn't inevitable, but with a criminal case, jail is possible, whereas with a civil case, it's impossible to ever have to go to jail because of a violation of civil law. So that's the first distinction I want to point out, is that criminal law, jail sentences are possible. Civil law, it's just monetary damages. And actually, before I go on to the next one, it's not always money. Sometimes there's equitable damages. And what equitable damages are is that you might be asked to do something or stop doing something. Like a government officer may be asked to perform some sort of study that they neglected to do, or a landowner might be asked to stop making so much noise. So you may be asked to do something or stop doing something. That's an equitable remedy, also available under civil law. But again, civil law, you're never going to go to jail. So the next distinction that I want to point out is representation. In a criminal case, you have the right to an attorney, and if you are too poor to get an attorney, one will be assigned to you. And the book mentions indigent clients, and it doesn't actually define what indigent means, but that's indigent. It means you're too poor to afford legal counsel, and so an attorney would be provided for one under the Constitution. Now, there is no constitutional right to an attorney under civil law. So if you don't have enough money for an attorney, you're out of luck. And that often requires people to settle when they maybe wouldn't have otherwise, or causes people to get really poor results, which is frequently the case in family law matters where one party is represented and the other party is not. So keep in mind, criminal law, you're entitled to an attorney. Civil law, you aren't. So those are two ways that you can sort of distinguish civil law from criminal law. Criminal law, you're entitled to an attorney. You could go to jail. Civil law, it could cost you a lot of money, and you're not entitled to an attorney. I just wanted to, I never practiced criminal law, and so I don't have a whole lot to say about it. But one area that I did have some experience was in domestic violence. And your text talks about when the police decide to press charges. And one of the times when they decide not to press charges is when there's an unwilling victim, when the victim is unwilling to testify. And back in the 90s, when I went to law school, I decided to get a job at a jail. I wanted to have some legal experience since I was going to law school. So I got a job working at a jail, and my job was interviewing people who were trying to get out on their own recognizance. So the person who had been arrested would come to my little window and say they wanted to get out on their own recognizance, and they would give me a list of people to call to who would vouch for their goodness and say that they wouldn't run away or be a flight risk. So, and you read about that in the text, that people could get out on their own recognizance or they may have bail. So I was the person who made that recommendation that I talked to people who knew that person, and that they all agreed that that person would be okay. And it was astonishing to me at that time, one, how many of the cases that came before us were domestic violence related cases. I was just really stunned to see it was really like 85% of the cases that came to me were domestic violence, and probably 75% of those, the abuser who was in prison had on their list of people for me to call to say what a good person they were, the person they had just abused. And inevitably, if I called that person, they would say, oh, yes, I want this person to get out of jail on their own recognizance. And I was really perplexed. And I've since had the opportunity to study domestic violence a lot more and learn more about the psychology of people involved in domestic violence relationships, and so has the police, especially since your textbook, which was written, which was in 2004. And since then, a lot more jurisdictions actually have taken this aspect of flexibility away from the police and said if somebody calls 911 on a domestic violence charge, that person's going to be booked whether the victim is willing to testify or not, because they were finding that so many people were not willing to testify because of the psychology behind those domestic violence issues. And what was happening was, it was just perpetuating violence. And so a lot of jurisdictions, including San Diego, where I had done that jail work, have laws now that if the police are called, people are going to be arrested, and it's just that straightforward. So that's something to sort of think about when you see the unwilling victim. Are they truly unwilling, or is there something else going on that's preventing them from being willing to testify, perhaps fear for their lives or their children? There's a concept in the law that I like, just the whole imagery of it, the fruit of the poison tree. And your book talks about this, but it doesn't give it this colorful name that we learned about it in law school. And what the fruit of the poison tree is when there's an illegal search or seizure, and that produces evidence. The evidence is the fruit. And the poison tree is the illegal search or seizure. So what the courts have found is that if there's an illegal search or seizure and it produces some evidence, that evidence cannot be used against an accused person. So let's say that you are driving along and you have a trunk full of drugs. And the police stop you because they don't like the way you look. And it ends up that they stopped you for an illegal reason. If they stop you and you stop, and they search your car, and they find these drugs, and they arrest you because you have these drugs in your car, they cannot then go and use the drugs as evidence that you were smuggling drugs. Rather, they'd have to come up with some other evidence that was obtained legally to convict you. And this is very frustrating to the police because it requires really that they follow the rules very strictly, because this is something that defense attorneys, as you can imagine, hop on all the time. If they can figure out a way that a search produced evidence, or that the search that produced the evidence was an illegal search, it gets that evidence thrown out. And often that evidence is just glaring evidence that somebody did something that they weren't supposed to do. But that evidence cannot be used if it was obtained illegally. So that is the concept of the fruit of the poison tree. So I don't have a whole lot to say this week, and you've got a ton of reading and several lectures and other things, so I won't go on. But I just wanted to share these couple of observations with you this week, and I wish you good luck as you move forward in your studies this week on criminal procedure.